great pleasure that I introduce the webinar titled Managing Risks During a Global Recession, Ukraine's Perspective. We have the honour today of hearing from several of the team at Hillmont Partners, one of Ukraine's fastest growing law firms with offices in Kiev and London, each of which will be exploring the pandemic on a variety of issues related to business in Ukraine. So the plan today is to run through a number of topics looking at Ukraine's reform and investment agenda to the functioning of the courts. They'll also be discussing bankruptcies and non-performing loans, a subject on which our first speaker and moderator today is one of the region's leading authorities. So please allow me to introduce James Hart. James is the founding partner of Hillmont Partners. In addition to founding the firm in 2016, James has a long-standing exposure to business in Ukraine and the wider CIS region. He began his career on the Russia and CIS desk at Standard Bank in London. From 2011 to 2015, he was a member of the management board of one of the largest alcohol producers in Russia and Ukraine. He was also an advisor to the former Prime Minister of Ukraine, and before that, an advisor to the former First Vice Prime Minister of Ukraine. James, welcome.
Thank you very much, and thank you everyone for joining us this morning. Thanks to the Legal 500 team for organising these webinars, which give us a chance to hear perspectives from around the world during this time of heightened uncertainty. Today, my fellow panelists are going to be looking at what the global downturn will mean for Ukraine and for businesses operating in Ukraine. And I am delighted to be joined by a fantastic panel of experts. Firstly, our guest speaker, Anna Lazarenko, who's the Chief Legal Officer of Delta Wilmar Ukraine, part of Wilmar International, who will be discussing some practical challenges that the company has been facing during this time. I'm also joined by my colleagues Taras Tertichny, Tatiana Milenko, webinar, and we will attempt to get through as many of those as possible. But if we don't manage to answer your questions during the webinar itself, please do send us your questions by email, and we will respond to all of them. Our email addresses will be available to you at the end of the presentation. I will be starting with a quick snapshot of the Ukrainian government's response to the pandemic and the impact that it has had on the country's legislative agenda, which is something that our government relations team follows very closely. So I've got the slides up, hopefully. Perfect. So I'm going to start with some research done by Oxford University, which has created an index that measures government responses to the pandemic. And what we see here, you'll see on the graph on the right of the screen, we've plotted Ukraine's response according to this index to that of the US and the UK. And I think what is striking to begin with is the fact that the Ukrainian response was early and it was very robust, very stringent. We need to be careful before drawing any conclusions, of course, of causality. Data is very imprecise at this time, but if we look at the graph on the right, we can, of course, see that on the face of it, the spread of coronavirus in Ukraine has been far less severe than it has been in other countries, here plotted again against the UK and the US. We see here a snapshot of the measures as they were examined in the Oxford University study, looking specifically at Ukraine's response. I'm not going to go through all of these. I've just highlighted here two measures where Ukraine is in fact behind many other countries, especially the world's largest economies, specifically income support and debt and contract relief. It's not surprising that these two measures that Ukraine is behind on these two measures, given that they are essentially underpinned by the depth of a government's and of a government's pockets, and as we know, the Ukrainian budget is constrained. My colleague Olga Staheva will come back to debt relief later on in the webinar. As for the impact on Ukraine's legislative and reform agenda, Ukraine has recently been in the middle of has been undergoing an unprecedented level of legislative activity, really peaking towards the end of last year, and it's not surprising to see that legislative activity has fallen throughout this period. However, there have been since March 17, 13 parliamentary sittings, and there have been 81 legislative acts that have been adopted in that period. Parliamentary committees and commissions continue to meet virtually, giving the opportunity for legislation to be discussed. And of course, the activity has been predominantly around emergency legislation through this period. But there have also been some important reforms that have passed during this period, to name a few: anti-money laundering legislation, the land market law, and the banking law that has been a hot topic of discussion for Ukraine's further cooperation with the IMF. Before I hand over to our guest speaker, I wanted to run a poll. So if we can get that up on the screen, to understand what you as the audience think, perceive the risks of doing business in Ukraine to be during this period over the next year or so. You'll see the question is, which of the following statements do you consider most applicable to Ukraine over the next year? Do you believe that the business environment will become more risky relative to other developing economies? Do you believe that the legal system will provide the tools necessary to minimize the effects of recession on companies in Ukraine? Perhaps there will be opportunities that will emerge from dislocation or asset mispricing, or maybe there will be little effect felt in the country. So if you could select the answer that you think most closely fits for Ukraine during this period, this will be a good opportunity to see a split of pessimists and optimists, and the number of opportunists that we have in the audience. Do we see a potential for upside in turbulence, or are we rather more cautious? So hopefully you will have had time to answer that question. If we can get the results up on the screen, that would be great. And so we've actually got an interesting split. A lot of opportunists in the audience. Very few people believe that there's going to be little effect. I think that's fair. But interesting to see that there's actually quite a broad range of answers on this one. I had perhaps expected a slightly more risk-averse set of answers. But we will be covering throughout this webinar both. Mainly we'll be focusing on risk, but we also touch upon maybe some of the opportunities that exist out of dislocation. I'd now like to open our discussion by turning to our guest speaker, Anna Lazarenko, who is responsible for managing the legal risks for one of Ukraine's largest agricultural companies and a company that is a major investor in Ukraine. Anna, thank you very much for joining us. Let's just make sure that Anna is connected. Do we have Anna by any chance? We seem to have a slight technical glitch. There we go. Great. Anna, thank you very much for joining us. So what's been keeping you and your team busy over the last few months?
Hello, thank you, James. Thank you for the invitation. It's very pleasant for me, and it's a great honor to take part in such a webinar. And I'm very pleased to share my experience. So, as James described, governmental response to pandemic, we as a food industry had to react very quickly and very properly in order to comply with all these changes and to keep our industry operating and working. And I should say that food industry belongs to the strategic one. So we had to maintain our work without any disruption. And at the same time, we had to comply with all the emergency legislation to not only to keep our operation without any pause, but to keep our people safe. So we faced three main aspects that I'm going to share with you. And the first one was labor issues and legal department. We had to refresh in our mind and we had to refresh in the minds of our HR departments, and we had to discuss it with our management. The labor issues, we had to do everything in comply with the COVID circumstances. So actually, we thought about remote work. We had to understand how we will arrange paid and unpaid leaves, idle time. We had to make some restrictions to the persons who have contacts with medical staff, because it's very dangerous in terms of infection, in terms of virus spread. So internal procedures, orders, different regulations, inside regulations, we had to correct and to share with all our staff to comply with all quarantine reality. Also, we're faced with administrative issues since our company had to work, but the transportation was banned. We had to do everything to arrange permits for staff for transportation on buses, on cars. We have created emergency response team who worked 24 hours throughout a week. We had to arrange deliveries of personal protection equipment. So actually all documents, actions, operations, activities had been in line with all emergency legislation and new reality, and we did our best to observe safety precautions. The second issue that I would like to describe is commercial questions. Since the beginning of pandemic, we analyzed force majeure clauses, and the legal department prepared new force majeure clauses, but we had to assess the risk for us and for our suppliers and for our clients in case we apply a new force majeure clause. And at the end of this deep analysis and communication with our commercial people and with our partners, we discovered that it would be reasonable to settle all the obstacles that we face within pandemic situation. We need to settle it commercially without stress to force majeure. Therefore, We reconsidered delivery periods. We reconsidered periods for payments required by the customers. So until now, we work constantly, and we don't have any claims with respect to force majeure. And I think it's very reasonable. It saves time, and it keeps our business like it was before the pandemic. The third very important issue, despite the ban, despite the permission of the government and our parliament not to apply with the requirements, with the requests to the business from the state bodies, we discovered that we have got within this period a lot of tax office requests, different requests from security service of Ukraine, local authorities, and even from antitrust committee. The antitrust committee, I would say, before it was very calm, and we usually received some requests, very ordinary, with ordinary questions. But now they became more active, unfortunately. So in most cases, we use the possibility to answer later on. In some cases, for example, if tax office sends the request regarding VAT, we reply within the required terms. But actually, I think that we overcome this also. Our legal department works remotely, and usually 1 or 2 persons work in the office if we deal with paperwork. And I would say that this quarantine time and pandemic situation that was new for us, and I hope it would never be again, but we have known and we have got a good experience, and I'm a positive person, and I usually think that every situation is a good experience and we need to find something good from it. And I have to share with you my opinion regarding benefits of this quarantine experience. So remote work for legal department showed that it is more efficient in terms of communication, in terms of documents exchange with internal clients and outside the company. Despite the legal department, we communicate within the company and with the partners. So online communication with all business divisions appeared to be more effective than offline, and we spend less time, and decisions are taken quicker, and it's a good point. And the third benefit that I need to mention is online education, and this is the best opportunity within this difficult time. And sometimes even me, I practice such stuff. I do something, and I'm listening to the webinar, and the best benefit from webinar that you can, after all, since almost all webinars are recorded, you can listen it again, and if you missed something, you can listen it one more time. It's very, very convenient. So we need to use all this experience, and the main challenge now is to come out from this situation, to restart all our daily activities with a new force, and face the reality with the renewed vigor and new skills. Thank you.
Thank you very much, Anna. Very interesting to hear some practical insights. It's clear that you've been very proactive in identifying risks that may be coming down the line, and looking to nip those in the bud. Also, good to hear and I'm hearing this a lot at the moment, that there is also the discovery that actually working remotely it can improve the efficiency, certainly in legal services. You did mention some particularly, I think, potentially worrying aspects around public bodies taking greater interest and becoming more active in this period. My colleague Tatiana is going to be speaking shortly about antitrust implications, and I know she will have some questions for you, Anna, on this topic. So if I can hand over to Tatiana.
Okay, great.
Hi, everyone. Let me welcome you in this webinar, and I really appreciate Anna allocating her time to be able to speak and share her insights. I'm also keen to know, pretty sure as other participants of our webinar, if you could share some more information, if you could share your pain points, maybe as relates to requests, probably information requests when it comes to Anti-Monopoly Committee of Ukraine. Are those information requests frequent, or are they too complex to be able to respond in a time prescribed by law? I mean, could you share some more details as to maybe if you feel it's too much for the business to cope simultaneously with pandemic and post-COVID recession problems and be able effectively to respond to AMCU requests, or you think AMCU is doing what they're doing and it's quite routine and normal?
Thank you very much, Tatiana, for this question. It's a very good one, and I'm very thankful that you have paid attention to it. Actually, this period of time, the requests from Antitrust Committee became more often and they less standard than it was before. And it relates to different issues: prices, volumes, deals, international deals, etc., etc. Even agreements with the state bodies like Ukrainian railway or something like that. And actually, since we know the approach of tax office in our country, when they send a lot of letters and requests, and then they do everything to impose penalties reasonably or unreasonably. Here, with respect to Antitrust Committee, we are a little bit suspicious, because we think that they will use this tax office approach, reasonable or unreasonable requests, to our mind, investigations, with the purpose to impose penalties and fines, to show their efforts to fill in the budget that is empty now in our country. This is our concern for the moment.
Thank you for sharing your news. This is really alarming and should be alarming to all businesses. And I think this is something also to consider for those businesses that conduct business in Ukraine. And also, I believe that this particular interest to your industry is well explained, obviously. You've been an agricultural company, but I think this is a good topic to discuss if other industries should be also alarmed. So I think, Anna, and I would suggest if we could run a poll to make this discussion more interactive with our participants. If so, the questions that we would kindly ask you to give answers to are the following: have you observed anti-competitive business conduct? So you may simply answer yes or no. And if yes, or if your answer is positive, please suggest tick either box which you believe that you really experienced, observed anti-competitive business conduct. So it could be either your directive competitors, or it could be some unrelated businesses, or maybe you've experienced anti-competitive business conduct from the side of you being a consumer. So your responses would be much appreciated. As you could see here, we have pre-selected for you some industries which we believe, based on our communication with clients and based on our feeling that pharma, retail, aviation, telecom, energy, logistics could be those which may raise certain competition concerns. So very hope that you did have a chance to answer those simple questions. And if we could now see the results, that would be great. Thank you for answering. Well, this is something we expected to see, that anti-competitive concerns are there. Well, another question is, of course, if those are grounded or no. But interestingly, when it comes to industries, pharma didn't raise so many of your votes that I would expected. And I see that energy is also the industry that is concerned. But I think pharma is still number one, and others have less votes. And telecom is not something that you're concerned about. So at least this is a good news. And aviation, well expected. Okay, thank you for sharing your views. And now I would be happy to share with you my knowledge and my insights and of our firm. So as all of you know, the coronavirus pandemic announcement has triggered an increase in the demand of foodstuffs. However, some suppliers and retailers may use this situation unethically, as you all probably experienced or observed, at least those who voted. And examples of such conduct, unethical or even illegal in some cases, could be unreasonable increase price for high demand products. There is even such term, price gouging, COVID-19 price gouging. And another such example of conduct is artificial creation of storage of certain categories of products in the market. So in certain point of time, the company may find itself in the status of an infringer and face accusation from the controlling authority and competitors, or vice versa, become victim of its competitors' unfair actions. Under COVID-19 law, so-called the Cabinet of Ministers became obliged to ensure the control over prices for socially essential goods, medical devices, and products. The goods in the list of social essential goods and services, which will be constantly monitored for prices and tariffs, includes a number of food products, such as buckwheat, rice, butter, chicken eggs, sunflower oil. So no wonder, as we just heard from Anna Lazarenko, her company is also under precise attention of Ukrainian competition watchdog. Then goes sugar, potatoes, as well as certain types of bread, flour, pasta, meat, etc. So no surprise, right? MCU also pays special attention to the prices of the producers and resellers of such products. Again, naturally, medical products and related products apologies, such as sanitizers, for example, constitute another area of MCU's focused attention. So please do be alarmed about this. When it comes to aviation sector in Ukraine, it would probably not be able to stay out of the MCU's attention as well, given the public outcry against air tickets price gouging. As you would see from my next slide, telecom companies should also be warned. In the beginning of March this year, the Competition Authority issued a number of recommendations in attempt to warn the companies not to infringe competition law. For example, in its recommendations addressed to pharma business, AMCU prescribes to refrain from any actions that may potentially contain features of violation of the legislation on protection of economic competition, which may lead to increase of the product prices. And having said this, AMCU also mentions that, of course, it is well understood that due to some currency fluctuations, right, there could be price increased, but those are deemed as justified. So price increase due to currency fluctuations are fine. This recommendation relates to both products manufactured in Ukraine and those imported from abroad. In addition, AMCU in its recommendations has requested not to advertise medical products that are allegedly effective against COVID-19 disease without officially proved therapeutical effect. And as we all know, and which has been reiterated many times by World Health Organization, still there is no medical product, medication with proved therapeutical effect. And I should say that some companies, some manufacturers in Ukraine do pose their products and place their advertisements in a way that implies real therapeutical effect. So potentially this may constitute a violation of competition law, which I will develop on later. Again, as already mentioned, telecom is another sector under precise attention of the competition watchdog. Moreover, Kyivstar, Vodafone, and LifeCell, the biggest telecom operators holding cumulatively 90% of the share on the market, also received recommendations from the AMCU. In particular, AMCU has requested to refrain from conduct that may result in restriction or limitation of competition, particularly through increase of tariffs, meaning unjustified, right? Elimination of affordable tariff plans, forced transferring or switching customers to more expensive tariffs. And this type of behavior we all as customers experience at one time or another during recent period, especially during quarantine, right? So AMCU reacted by issuing those recommendations to, and they were addressed particularly to those three mobile operators. Further, media companies, including radio, TV, they have been warned by the Competition Authority not to disseminate misleading advertisement on medical products that are allegedly effective against COVID-19. So again, this recommendation by AMCU goes to both sides, to those who place advertisement of their products and those who offer those services of advertisement.
Tatiana, if I could just intervene here.
Sure.
To what extent are these recommendations binding, or are these simply prescriptive? And also, just a point to the audience, do feel free to put questions to us during the panel. We did receive a number before the webinar, which we will look to get through. But if you have questions on this, do please send them through to us in the chat box.
Yes, thank you, James. Well, this is very important. Very important question, and I should say that again, according to the law, it says that recommendations or guidelines, if you like, issued by the AMCU must be observed, right? Must be adhered to by those to whom they are addressed. So the law does not explicitly say that they must be implemented or they must be followed, but those businesses, the addressee, recipients of those recommendations. And I should again reiterate that those could be individual, more like style, addressed to one or few particular companies, or they could be addressed to industry or to all undertakings. So those who are concerned, those undertakings must consider those recommendations, and my advice would be, of course, to follow them, unless they are greatly unreasonable in undertaking's opinion, and then there could be another matter. Well, and this is something for to discuss with legal and to seek legal consultancy. But generally, I should say the AMCU, at least from what I observed during the last 5 years, when it comes to general recommendations, they are quite reasonable, at least I should say. So this I hope this answers your questions. So moving to my next slide, I should also say that the business conduct may be potentially qualified, meaning anti-competitive business conduct may be potentially qualified as abuse of dominant position or anti-competitive concerted actions. So let me start from abuse of dominant position, then I will go to the other. So if we talk about abuse of dominant position, this would include such examples as, for example, unreasonable increase of prices, or vice versa, predatory pricing. And unreasonable increase of prices means increase of prices which would otherwise could not be increased if there would be undistorted competition on the market. The Ukrainian main competition law, the law of Ukraine on protection of economic competition, condemns such culpable unilateral conduct. And if the competition authority finds such a dominant position and abuse, it may impose a fine on the dominant undertaking. And the most important thing here, and which probably explains why not so many cases with such qualification are there, is that MCU, similar to competition authority NCAs in other jurisdictions, not only in Ukraine, must obviously prove two important things. Is that firstly, there is dominancy of this particular undertaking, of few, depending on the case, and there is actually the fact or the fact or facts of abuse by such undertaking or undertakings of dominant position. So speaking about monopoly or dominant position, interestingly to know that Ukrainian legislation, unlike European, for example, acquis, does not differentiate monopoly and dominant position. So speaking about monopoly or dominant position in the market, the undertaking is deemed to have it if it has no competitor in such market, or it has not significant competition due to limited possibilities of other undertakings, existing barriers for entering the market, other financial subsidies, or other market barriers. And the abuse of dominant monopoly position is the conduct of a dominant undertaking that is likely to result in either of two. So there is a very simple test. The question you have to ask yourself, if your conduct may potentially fall into such that being qualified by the watchdog as restriction, elimination, or distortion of competition, or hindering the interests of other undertakings or consumers that would otherwise be impossible should significant competition on the market have existed. And it's very important to mention, once again, probably all aware, the liability prescribed is quite severe. So the maximum is the fine in the amount of up to 10% of the worldwide turnover for the preceding financial year. So yes, again, there are guidelines the MCU issued which are not really binding for the MCU, suggesting the mechanisms, the ranges, and they are much less. But again, under the law, there is still the maximum ceiling is of 10%, which is quite substantial, of course. I would not overwhelm you with any examples, but just maybe to mention that most common is imposing unfair purchase or selling prices or other trading conditions, which would be impossible to impose otherwise should there be no dominancy, right? So should there be significant competition on the market. Also applying dissimilar prices or other dissimilar conditions. So I'm talking about rebates, tying, right? Also exclusivity and other types of culpable conduct. And on the other side, so if there is a situation that MCU suspects there could be anti-competitive conduct, it most likely will not pursue the companies through the first track, let's say, but would try to qualify it as anti-competitive concerted actions. So either vertical or horizontal, depending on the outset in a particular case. So in order to be considered anti-competitive conduct, the AMC should be able, on the basis of course, evidences, it should be able to prove existence of either of the following negative consequences of such conduct. So it's either significant restriction of competition in the market or a substantial part, or market access restrictions in relation to undertaking, or economically unjustified increase of the prices or deficit of the goods. So the competition law contains non-exhaustive list of prohibited concerted practice. I will not take much of the time of the other speakers, and just wanted to make sure that you also point attention that for this type of conduct, anti-competitive concerted, again, up to 10% of worldwide turnover fine for the is prescribed. So you should also be very cautious in this respect. So make sure that your company is not involved in any type of potential culpable conduct. No COVID-19 price gouging, please. And please also mind another trap which might be tempting for to fall into, which is dissemination of misleading information. As I already mentioned, some manufacturers have already been warned by MCU not to place ads of the medical products which have allegedly anti-COVID-19 effect, because they obviously not. And for this type of violation, the law prescribes fine of up to 5% of the worldwide turnover for the previous fiscal year. So my recommendation would be to keep working very closely with your cell departments to ensure compliance with the competition law. I think this the preceding months and the months to come should be pay specific attention to compliance, to antitrust compliance, and when in doubt, of course, seek external legal advice. So,
thanks, Tatiana. Yes, some very potentially serious consequences, and something for companies to keep a sharp focus on. We've got a couple of questions, but I think we will push on with our next speaker and hopefully come back to them a little bit later. Sure. So I'm going to now turn to my colleague Taras, who is going to be looking now at regulatory and governance issues that have arisen during the quarantine period. Taras, hopefully we have you here and connected. If I might ask you first of all to tell us a little bit about what companies have faced in terms of their corporate reporting requirements during this quarantine period, which has of course been a very challenging period for companies to be able to adhere to such requirements. don't seem to have Taras at the moment. Taras, can you join us? I feel highly unqualified to take this section over on your behalf. No, it looks like it comes down to me to discuss corporate reporting requirements. No, I won't make you all suffer my amateur view on reporting requirements. I think what I'll probably do is look if we can move to another speaker whilst we are looking to get hold of Taras. We after Taras are expecting to be studying the spectre of distress, which my colleague Olga Stakheva would be discussing with us. I don't know if we can connect Olga in Taras's place, and we'll come back to Taras shortly.
So I've appeared online in Taras's absence. I'm not going to speak. I'll bring Olga on.
I think, James, you and I discussing corporate requirements or insolvency legislation might be rather painful for our audience. So we have now Olga, as I can see, has been joined. And do we have mic and audio for Olga?
Olga, you are live. If you want to activate your camera and microphone, you'll be brought into the webinar. There's a palpable sense of tension.
There we go. Wow, we've got you, Olga. Thank you for managing to join us. So, as I say, we're going to be now looking at what happens as in an environment where distress and insolvency is rapidly becoming a greater consideration. Of course, insolvency is not now only a risk for fragile businesses, but ordinarily healthy and viable businesses are also at risk. So, what should these companies be looking out for?
Thank you, James. Hello, everyone. Thanks for joining our webinar. I hope you will enjoy it and will take an active part in it. As James has correctly pointed out, today we will be looking at the problem of distress and the problem what businesses should be doing once they face such problems. Given that today's topic of our webinar is managing risks in times of recession, I suggest we look at the bankruptcy-related topic from a slightly different angle. First, let me just make a statement that in Ukraine, many tend to associate bankruptcy law with such situation when a company is deeply distressed, say, is over-indebted, and tend to use bankruptcy law in quite often only in situations when there is a liquidation procedure in mind. And today, we will try to change that perception, and we will try to guide the audience, our business, that are doing business in Ukraine, to raise the awareness that the bankruptcy law is the law that should be taken care and kept in mind, not only at a very bad distress situation, but in the zone of distress, in the zone of insolvency, and not necessarily when the business already faced cash flow liquidity problem. That's why I suggest that today we will look at three subtopics. First, we will define what are the bankruptcy-related risks businesses in Ukraine may face today, given that today we have a new bankruptcy code, which is different from provisions that we previously had, and the bankruptcy code fully entered into effect on 21st October last year. Then we will look at Parliament's response to, say, COVID-related challenges and the risks. And lastly, we will look at legal instruments that are available in the new bankruptcy code to help businesses stay afloat. So let's start with the first question. First question is key bankruptcy-related risks. I'm sure many of you are aware of this or that risk in your domestic law. And given that each jurisdiction has its own peculiarities in terms of bankruptcy law, Ukraine is no exception. Our bankruptcy law, Bankruptcy Code of Ukraine, as I said, a new one, provides a very new, progressive, but at the same time risky for today's environment provision. Expressly, I'm talking about first risk, which relates to the possibility that the directors of businesses may be held liable for the debts of the company in certain circumstances. What it means that today the new Bankruptcy Code of Ukraine envisages a direct duty of the director of the company to file for insolvency, for bankruptcy proceeding, should the threat of insolvency take place. This is how the Bankruptcy Code expressly states. This duty is fully in control and is fully in hands of directors, and they have to file for bankruptcy within 1 month as of the date of occurrence of a threat of insolvency. The threat of insolvency is a quite, let's say, not vague term, but still has many questionable gaps. But the way the Bankruptcy Code envisages that and construes the threat of insolvency, it states that it is merely the situation when a debtor company understands that if it pays to one creditor or two, it may not be able to pay to other creditors in full. So this is merely the situation when basically today in COVID times, when we have certain restrictions, okay, now they have been slightly softened, but still businesses, any business can go and say, hey, I'm in a threat of insolvency because I understand that if I pay you, I will not be able to pay to other creditors in full. So in this case, the director would have this is a direct obligation to file for opening of a bankruptcy case. So this, and in case the director doesn't do that, he will face a joint personal liability for the debts of the company. So this is the first bankruptcy-related risk under the new provisions of the Bankruptcy Code. And the second risk is potentially a huge tsunami of involuntary bankruptcy cases that may be initiated by creditors, not the directors in previous case, but by creditors. This threat is at hand again due to new provisions of the Bankruptcy Code, and the reason is that previously we had certain entry thresholds to enter the bankruptcy case. You had to, the creditor, for example, had to have pecuniary claims in a certain amount, about 47,000 euros. Then it had to obtain a court decision on enforcement and go to the enforcement authorities and get a writ that wasn't fulfilled within 3 months. And only then the creditor could initiate bankruptcy case before the commercial court. But now the Bankruptcy Code lifts all those thresholds, entry thresholds, and says there is no requirement for a creditor to have any money pecuniary claims against the debtor just to initiate. At least the creditor has to show that there is no dispute regarding a certain monetary claim. And the creditor can go to the bankruptcy commercial court and file a bankruptcy proceeding. The creditor would only have to pay court fee, about 700 euros, and the new requirement is to pay advance payment for trustees' remuneration. So given all this, just to sum it up, given that the new bankruptcy code of Ukraine has relaxed the thresholds for entering bankruptcy cases by creditors, we may face a certain risk that the court system may be overloaded by a number of bankruptcy cases, either initiated by creditors because they can easily enter the bankruptcy case against the debtor, or we can face another problem that debtors may in directors face on behalf can actually initiate the case because they are obliged to do that because they will face the joint liability otherwise. So these are the two key risks. Let's have a look what Ukraine has done or is doing currently to overcome, or at least temporarily, such risks. We have a draft law 3322, which was already in April 10th April 2020. It was in the parliament and it is still under consideration in the committees. It passed first reading, but still is waiting for a second reading. And what it suggests sort of anti-COVID measures, temporary measures that will help businesses sort of have a breathing space for the lockdown period and 90 days thereafter, for the businesses to stay afloat and maybe take necessary actions to prevent going into bankruptcy cases as such. What I will not mention all the provisions that are suggested for the draft law. I will stress on the most important ones, which is the suspension of director's duty to file for bankruptcy within the lockdown period and 90 days thereafter, which is deemed reasonable and a good measure if the law is passed eventually in the parliament. Also, a prohibition that creditors will not be able to file for bankruptcy case subject to certain conditions, that the debt arose no later than 1st February. These conditions seem to be reasonable proposals and quite logical to implement and adopt given the COVID circumstances and possible distress that companies are already or will be facing once they are running out of all their operational liquidity. On the other side, I put it under question mark, is the introduction of a possibility to hold creditors' meetings remotely, either by video conference or a poll, and the suspension of all pending bankruptcy procedures, of moratorium, of electronic auctions for sale, and etc. I've put these suggestions under question mark because the first one is obviously a good one, but within the professional circles we have discussions that it might be a bit difficult to implement remotely, to hold remote creditors meetings in Ukraine's circumstances, because parties may not be very well equipped to verify the signatories' signatures and stuff, so that may pose some problems. And suspension of all bankruptcy cases that are already pending in a court also is deemed questionable, as the pending cases that they should continue. I mean, I personally don't see the reason why they should stop, because otherwise that will impede the whole process. I mean, if there is a bankruptcy case already in place, there should be no reason why it should be stopped. Because the debt has already been occurred, the creditors already are in the process, and it's only, I don't know, some of force majeure circumstances may only impede the pending bankruptcy proceedings. Okay, and we smoothly came to our third subtopic, is legal instruments to overcome distress, which I found the most important in today's circumstances. We need to analyze what exactly businesses can avail of in distress. Whether the bankruptcy code of Ukraine, with its new provisions, provides any lifelines for businesses to support them to stay afloat. I divided the legal instruments into two blocks, which is out of court rescue procedure. Also, such option is viable and is a reasonable one, especially in today's circumstances. And we will be briefly speaking about preventive restructuring. This is the instrument that is available under Article 5 of Bankruptcy Code of Ukraine, and the financial restructuring procedure. This is what I call not purely bankruptcy law instrument, but rather, as I call it, banking and finance instrument, because it's a powerful instrument that parties can use. However, we have to remember that exactly financial restructuring instrument is only applicable for the cases when among the creditors, the debtor has at least one financial institution. So this has to be borne in mind, because not in every case the debtor can avail of this financial restructuring possibility, only subject to those provisions. But coming back to what I want to dwell on more, as an example of a very good legal instrument that is already available under Article 5 of Bankruptcy Code of Ukraine, is the preventive restructuring. It's an out-of-court rescue procedure that allows debtors, no matter what creditors they have, to restructure and in such a way that they may prevent going into bankruptcy proceeding. That's why I pay attention to the businesses today, that exactly preventive restructuring under Article 5 is the best option for the businesses to avail of in today's circumstances. Many may wonder how it works, who can apply. Of course, the procedure itself has its own peculiarities. It may look straightforward, but still has points to be borne in mind. Today, we will not, unfortunately, have enough time to discuss every step of the preventive restructuring procedure. But what I want to highlight for the businesses, that they should be taken into account that once they are not insolvent, once they are feeling that they are merely in the zone of insolvency, that they may have problems, but problems have not yet there. They should be taking this legal instrument in their hands and try to negotiate it with their creditors. Just to point that out-of-court rescue procedure is a procedure that allows only debtors to take the initiative in their hands to pick up, let's say, affected creditors. It's not a collective procedure as the court procedure. They select creditors, the affected ones, with whom they want to negotiate a restructuring plan. They develop a restructuring plan, rescue plan. They hold creditors' meeting at which they obtain certain thresholds of votes in values, and then only then they apply to the court for court confirmation. This preventive restructuring, or as I call it, out-of-court rescue procedure under Article 5, is a very good instrument that viable businesses should be considering and taking actions, especially now when if the Parliament adopts some temporary measures in terms of suspending the director's duty to file for bankruptcy cases. They should try to actually negotiate and restructure and rescue their business outside court without going to the bankruptcy case. So this is the main message. Do take advantage of this preventive restructuring because it is cheap, it is fast, and it allows you to restructure with certain creditors that you may fear that you may have problems. And just a couple of words about court procedures. Yes, we do have court procedures under the Bankruptcy Code of Ukraine. They are typical. They also are not very bad option as many may think of, like having a negative stigma of bankruptcy. But still, if you feel that you can't restructure under Article 5, you can go, of course, under court procedures within bankruptcy case, and first you will undergo the administration within which you can, under the moratorium, prepare the restructuring plan, and then finally you can develop and confirm within court supervision the rescue plan itself. So this is mainly it. Main message: do take advantage of negotiations now. Don't wait till you are insolvent, because the Bankruptcy Code of Ukraine provisions now allow you to restructure at an early stage in a mere zone of insolvency. So my main message: stay healthy and stay viable. Thank you for your attention.
Thanks very much, Olga. We have a question. We're slightly tight on time, so we can't get through everything. But we have a question here regarding the new bankruptcy code and directors' liability for the debts. Is this liability activated irrespective of unlawful behaviour in these cases? Yes.
Actually, the duty of a director to file for bankruptcy is a must. It's an express provision of a bankruptcy code saying that if you haven't done that within 1 month as of the occurrence of a threat of insolvency, you will be liable. That's it, full stop. We have another provision when the debtor or the shareholders, if they are found in doing unlawful things, they may also be held liable, not personal liability like joint liability, but subsidiary liability. But that will have to be proved in court and in liquidation procedure. But for this one, the joint liability is only without unlawful. Just you have to strictly observe the one month term as a duty to file for bankruptcy. Yeah.
Okay. Thanks very much, Olga. Thank you for taking us through the options that exist for companies facing the threat of insolvency at the moment. We're now going to move to my colleague Andrei Chornous, who will be looking at the dispute landscape in Ukraine going forward. Andrei, if we have you. There we go. Great. Hi, Andrei. So a key theme for companies in this time will be negotiating and limiting losses. Losses caused by debtor delinquency, losses caused by contractual breaches. And it's, of course, not always possible to nip these issues in the bud, as Anna Lazarenko's team at Delta Wilmar is aiming always to do. Inevitably, some of these matters end up in litigation. How do you see the disputes landscape in Ukraine over the next year or so?
Yeah, thank you, James. Thank you, everyone who is watching this. I think that obviously this the main ramification of the COVID for contractual obligations is that the delinquency and breaches will only rise. And the main thing that probably was the most popular legal request that we have received for the last couple of weeks was the force majeure event, which could be in Ukraine recognized only by the Chamber of Commerce, which is the main one or by its regional departments. And it's noteworthy to say that the COVID itself was added as a force majeure event on 17th March this year, but still it's not the perfect remedy for any breach. And in order to duly recognize such events, a certificate must be obtained from the Chamber of Commerce, and this is the place where some issues may appear. In particular, in practice, issues may be related to the essence and the nature of particular relations when parties default their corporate, commercial, or tax obligations, and they it is necessary to identify this is where truly impossible to perform one's obligation due to COVID, or the party just didn't see practical sense in this. And also some dishonest or dodgy companies may abuse such right by obtaining this certificates just to avoid liability and just to justify the financial failure. So companies and honest businesses should be aware and should properly react to any breaches. And like a next step to any unsuccessful obligation or dispute is the court. And also some changes were related to online justice. In particular, according to the judicial reform of the last year, there was electronic court introduced. However, it was not popular, and it started emerging only when the COVID outburst in Ukraine. And as of now, to participate with the court hearing, a party or a participant of the case must submit a motion 5 days prior to the court hearing to the court and to the parties, and must register at the official website court.gov.ua and use this official digital signature to sign all the motions and documents that are submitted. So this is like the main what you should think. So after this, maybe you can just turn on the poll that we want to share with our participants of the webinar, and just to, since almost everyone here is a legal practitioner, it would be really interesting and useful to get their get their thoughts, how popular will be electronic justice after the COVID in terms of our new realities. So the options are, it would be unpopular, less than 15% of all hearings. It will gain popularity from 15 to 30%. It will play a major role in the judicial system, 30 to 50%, and it will actually overcome the conventional hearings. So please make your guess. And I hope everyone tick the box. So probably let's see the results. Oh yes, so we'll start gaining popularity. It's obviously the most popular option, and I actually thought the same. So up to 30% of all hearings will now be online, and actually from practical experiences, really useful and convenient. However, there might be some technical peculiarities. For instance, when my colleague participated in a court hearing, judges turned off the video but forgot to turn off the audio, and the participant managed to find out some really interesting information about the judge's opinion. So a hint is that everyone should be really cautious when they're using some software, and in particular only one software is allowed. This is EasyCon software, so stay cautious. we can, I guess, turn the poll. Okay, so now we can move forward, I guess, to the NPL market. NPLs are non-performing loans that banks are unable to profit from, and this is just an example. And I move forward to like a really widespread type of contractual breaches that is currently really widespread, and it distorts the Ukrainian economy. So NPL is actually loan that was not repaid, and the pledges and mortgages that such a loan together with the loan right and the loan could be purchased via the auctions. And due to some events and unpleasant economical situation during 2015-2017, the total number of NPL in Ukraine actually exponentially rise, and it was more than 50% of all loans provided by banking sphere. And only in August 2018, it dropped below 50%. And like this year, as of 1st April this year, the total value of all NPLs amounts to $15 billion. So this is a really significant part of the whole loan banking system. So further, I guess we can just discuss about investing into Ukrainian NPL market, because on the one hand, NPLs are really attractive financial investment, and they could be really profitable, and the loan portfolios are quite commonly diversified. In particular, they commonly comprise from 75% for corporate loans provided to businesses, and for 25% to consumer loans to given to natural persons. The price is low, and commonly the price is much lower than the market price. Competition is low as well. To purchase an NPL in Ukraine, you should participate in a public electronic auction. Commonly, they are provided by Prozoro system or a state enterprise Setan. And also, the Ukrainian legislation provides several options for out-of-court collection of collateral. In particular, if you purchase some perspective of financially attractable loan, you can just out of court, based on a notary and enforcement proceeding, collect any necessary, any attractive mortgages and pledges. However, you should also remember that any investment in NPL is a risky one. Also, major news that appeared recently, in particular on 15th April this year, this was the unlock of NPL sales by state banks. Actually, this is really significant to our banking sphere and economy, because for like 75% of all loans given by state banks, in particular by Privat Bank, were non-performing and distressed. And such unlock only provides our banking sphere to release some problematic loans to the market, and the market to get some attractive benefits from it. So the main change is that now the loans could be sold, and this comparing to what was before, because before loans could not, state banks didn't want to sell loans lower than the par value, this balance value, due to some risks from criminal mismanagement and so on. But now they can be sold through the Dutch auction model. So through this model, the starting price would be the par value, and it will be gradually lowered. The loan cannot be transferred still to borrowers or related parties. And for the first two auctions, the starting price of the NPL would be par value, but eventually it could be still decreased and defined lower than the par value. But before making such a risk investment, although it might be financially attractive, you should think about some precautionary legal measures. So what we mainly advise is and recommend to potential buyers is to necessary steps is pre-acquisition legal asset due diligence. So first of all, you need to find out who sold the asset, who is the borrower, some background about the borrower, check the registers, in particular the court judicial register, property registers, make some criminal check and find out some political background, whether the case is sensitive or not, and to find out whether there are some personal guarantees and whether they are enforceable. So there are actually a lot of legal pitfalls that potential investors should look at. Another point where lawyers could step in, it's the due diligence acquisition process of the asset and the cleansing process. So this is when the auction is being made, but there are also some technical and legal advices that should assist in making the deal and should help when the deal is over, but how to duly register the ownership right on the demand right. And also the recommendations could be useful during the asset management stage. So I guess this is the main points. And
thanks very much, Andrei. Yes, I'm glad to hear that judges face technical difficulties and not only organisers of webinars. Also, a lot of interesting points over NPL. The market clearly opening up now with this change, a long-awaited change that it would allow state banks to sell their non-performing loans at a discount. And I also note that there's a big move at the moment to improve the state's capacity for recovering monies owed to it that have been siphoned out of the banking system over the last few years. And there is a new law that is passing through the parliament at the moment, which looks to allow the state to raise litigation funding to recover assets, which is another area, I think, a large development for the country. We have now managed to get Taras back. We are running towards the end of our time slot, so we will, I think, have an express discussion over corporate governance matters. Taras, maybe if I could ask you to just talk us through what you see the main prospects in corporate law over in the coming period. Obviously, in the quarantine period, there have been some mechanisms provided in legislation that provides companies with a little bit of headroom, those that have reporting requirements. So how do you see the situation at the moment?
Yes, indeed. Do you hear me well?
Yes.
All right. I've been told that the sound may be not very well, so I will be shouting in the microphone.
It's fine. We can hear you loud and clear, Taras.
All right. Excellent. All right. If I may have the presentation, because I have a list of these new things that inevitably we will have here in Ukraine, because as James pointed out, we are still on a reform track, and we have new bits of legislation every several, new important bits of legislation every several months. So what we should expect in terms of new legislation? We expect new law on the joint stock companies and corporate governance. Now, that would not be a new law, but there will be significant amendments. For example, the amendments will provide better rights for shareholders, both in joint stock companies, but also in limited companies, to file derivative lawsuits, which are lawsuits in the interests of the company against third parties, and particularly against the management of these companies. Also, in terms of new legislation, we do expect a major review and remake of the capital markets legislation. Essentially, we are going to have new regulation which will be harmonized with European Union laws, and that may help the capital markets in Ukraine to develop further. What we have right now is that following the quarantine and following the crisis which is already coming, we naturally expect probably less classic M&A deals, but we do see and we feel and expect other transactions, investments, and other financial operations. As been mentioned by James and Andrei previously, we do expect more NPL sales here in Ukraine because the state banks have been unblocked to sell their demands against their debtors. By the way, 2 days ago, we had a very interesting NPL sale. The Deposit Guarantee Fund of Ukraine has finally sold a stadium in Odessa, a big football stadium complete with offices and hotels, etc., for just $7 million. So you do have this specific M&A things that you have in Ukraine. Moreover, we have so-called small-scale privatization ongoing, which is below $10 million, but still there may be quite interesting objects. Right now for sale, for example, is a hotel in the center of Kiev with 200 rooms, and which is sold by the State Property Fund of Ukraine. And the State Property Fund of Ukraine, which is now run by former investment bankers who know how to sell assets, apparently. They are requesting for the interests of the potential buyers. Therefore, we do have some interesting things. Moreover, some industries we have some new markets opening for investment. For example, these markets may be oil and gas and natural resources. It was quite closed and restricted and very corrupted. Right now, we have an increased transparency on geological information, which is a crucial thing. And we have land plots and exploration licenses being auctioned on public auctions. And the market is much more free and competitive, and a potential investor may find a good deal for the company. More, by the way, right now we don't have many M&A deals, but we do have several greenhouse investments in the field of natural resources exploration and oil and gas, which we are solving right now. Moreover, we do expect new companies entering Ukrainian market, in particular in logistics and transportation. For example, we do have one international company which is vigorously entering Ukrainian market in the field of courier delivery and related services. And of course, they did have a boost in their business, as well as a lot of problems, of course, during the quarantine restrictions. And we expect more logistics and transportation companies to move in Ukrainian markets. Another interesting sector which is going to open soon is gambling, which is basically prohibited in Ukraine and was working. It was, of course, there, like in a gray market or illegally or semi-legally present in Ukraine. But right now, the parliament nears the point when the new gambling law is going to be approved, and we do expect new investments. For example, the stadium which was sold in Odessa there is a rumor that the stadium has been sold for the sole reason that it has a good hotel built in, and when you own a 5-star hotel in Ukraine under the new gambling law, you will be allowed to establish a casino there. So again, we have many interesting opportunities, which is not as in other country, but in Ukraine, if you look attentively, you are going to have very interesting things. Moreover, there are other interesting sectors, maybe software development and software product development. For example, Ukrainian built startup Grammarly, which you are probably aware, that is a very well English language editing software. They are beginning to invest themselves, and just recently they bought an American company. So again, Ukraine is not your usual market, but there are opportunities. And what is good that in certain areas the regulation becomes more transparent, more competitive, more fair, and more understandable for international investors.
Thanks, Taras. We're coming to the end now. I think we can probably squeeze in one question. We've received this question from a number of different participants, and that is around renewable energy. And I hope I can bring in Tatiana, who was at a meeting with the Prime Minister yesterday on this particular subject. Tatiana, very briefly, as we're going to be ending very shortly, what is the latest on tariff restructuring for renewable energy producers?
Thank you for the question. And well, this obviously is not at least directly related to the topic I was speaking to, but we'll gladly share the insights with the business. Indeed, yesterday there was, as planned, final, but in fact that was pre-final meeting between business and government, represented by Prime Minister, by temporary acting Minister of Energy and Environmental Protection, as well as Deputy Head of Office of the President. So the key thing to discuss was actually the cuts, the indicatives of feed-in tariff restructuring, which would fit and be acceptable to both to business and to renewables producers, to developers, and to the state, to the government. So what was offered actually, and this was in the opening remark by the Prime Minister, is to have the reduction of 10% for wind and 20% for solar. And the reaction of the business was not warm welcoming, so to say. The business, I would say, strongly opposed, and but some producers still think that this, as a worst case scenario, could be possible. But the majority of renewables producers, energy producers from renewables, as well as specifically foreign investors, they insisted that the worst case scenario possible would be minus 7.5 reduction for wind, and minus 15% for solar. And if there is installed capacity for specific solar power plant, which is less than 10 megawatts, then it could be 12.5. So basically, there was not a happy end yesterday, but both sides are still hopeful to reach the agreement, which will end up in voluntary restructuring. And this point was also highlighted by Dirk Buschler, who participated via teleconference as a mediator in these negotiations between business and the government, pointing that the key thing is to have voluntary agreement on restructuring, not just cuts, but restructuring. And the key thing here also that cuts, and this what was voiced out by investors, there should not be just cuts, but those reductions should go together with at least 2 years extension. This is the key, I think.
So
yeah, so we'll see how things will develop, but
new
both sides
legislation.
are very hopeful to reach their agreement.
We've been waiting for this new legislation for quite some time now, so hopefully we will actually get sight of it soon. Well, I think that draws us to the end of our webinar. Thank you very much to firstly to our guest speaker, Anna Lazarenko from Delta Wilmar, and thank you to my colleagues for sharing your insights. Thank you to Legal 500 for putting this together for us. And lastly, thank you very much to all of our guests who have joined us. Please do take the opportunity that we will share these slides, and please do take the opportunity to get in touch with us. You have our email addresses. Send us any questions that we have not been able to cover in this webinar, and we will answer them for you. So thank you all very much for your time this morning.
And can I say a huge thank you to the team at Hillmont Partners for putting this together, a really insightful series of presentations here. I don't know if it's possible, please, Ben, to cut back to the slide with the partner contact details on. I'm sure there'll be lots of questions, not only from those in the Ukraine, but from those who have joined us from outside Ukraine today, and indeed watching the stream of this later. I should say that a recording of this will be live shortly. Obviously, there's a lot of information here, so it's probably worth a repeated view. So please do contact James or any of the other partners if you have questions. So thank you all for tuning in, and a huge thank you to our speakers today: Anna Lazarenko, Tatiana Milenka, Andrei Chornus, Taras Turichny, Olha Stachaeva Bogovic, sorry, and of course James Hart. I managed that one. Thank you very much.